Hello, everybody, and welcome to the first lesson on the subject of the English legal system. What we're going to do in this lesson is essentially define some of our terms. So we're going to introduce the subject of the English legal system, for example, define what the English legal system is, why it's important that we are very precise with our terms in terms of English legal system, and we're not referring to other phrases to define things like the United Kingdom, for example. And then we're going to define the scope of this series of lessons. This is a series of lessons which is vital to anybody who is studying law at university in England and Wales. The reason for this is because what this course is going to allow you to do is have a very introductory, basic understanding of the way in which the English legal system works and operates, the role of each of the individual component parts within this system. So what does the role of the judiciary entail? What does the role of Parliament entail? All of these things are going to be vital for your study of other areas of law. So if you're going to then go and study contracts, if you're going to then study the criminal law, you're going to have a better understanding of how all of these things fit together after you have gone through and looked at these lessons on the English legal system. I would also like to note as well that pretty much every single university course or institution in England and Wales will have a module that it would be compulsory in their first year on the English legal system anyway. So this is going to form part of that study. When we talk about the English legal system, what we're doing is referring to a very specific and detailed and precise thing. We're talking about the legal system which structures law in England and Wales. This is just another way in which we can reword and conceptualize what we mean when we talk about the English legal system. But the first question you might be asking is, well, some people might be living, you might say that you live in England, but the country that we are from, the country that is in which you are studying, is the United Kingdom, surely. So isn't it better to call it the United Kingdom legal system or the UK's legal system? Well, because we're talking about the ways in which law is administered and made in this country, we have to be very reticent to the fact and very aware of the fact that depending on which of the countries within the United Kingdom you are in will depend on the legal system in question. So the clue is in the name. We are a United Kingdom of the United Kingdom of Great Britain and Northern Ireland. That is the official title of this country. But that means that there are various different sort of countries that exist within this United Kingdom. And so while we're in the United Kingdom of Great Britain and Northern Ireland, and this is the official title of the country, the law exists in different ways in different parts of the country. So, for example, in Scotland, they have a very different law to England and Wales. That is why when we talk about the study of the English legal system, we are referring to a very specific thing, and we are not referring to things such as, for example, Scots law. What about the emphasis of England and Wales? We know that the United Kingdom is made up of Great Britain, which is made up of England, Wales, and Scotland, and then you also have it's the United Kingdom of Great Britain, which are those three countries, and Northern Ireland as well. Well, if that's the case, then surely England, Wales, and Scotland all have different legal systems. Well, the reason why we say England and Wales is because ever since around the 1200s, England and Wales have had merged and co-developing legal systems, such that the common law, the English common law, has developed within both jurisdictions. And so the legal annexation of Wales was achieved by Parliament in the Wales Act of 1535. So for the longest of times, England and Wales have had similarities in terms of their legal systems. The common law has developed in both of these legal systems in conjunction with each other. And so when we talk about the legal system that we are referring to in this series, and what we'll be referring to when we do, for example, criminal law, and when we do, for example, the law of torts, we're talking about the legal system of England and Wales. In recent years, there have been movements when it comes to the issue of devolution, which we're going to get to when we look at a series of lessons on constitutional and administrative law. But essentially, legislation that was introduced by New Labour with things like, for example, the Government of Wales Act has led to a situation where further laws have been made that can be distinct from England and Wales, that have been made in Wales with the Government of Wales Act. We're going to get to the importance and our understanding of what devolution does and the impact of devolution in future lessons' time, but it should just be noted that the law of England and Wales is considered to be separate to, for example, the law of Scotland and Scots law. And this brings us to Scotland, because essentially, why is it the case that even though we are a part of the Great Britain, we are part of the United Kingdom of Great Britain and Northern Ireland, why is it the case that Scotland is therefore separate in our studies of legal systems? Well, when Scotland became part of the United Kingdom, when it became part of Great Britain, it did so under the Act of Union, following the Act of Union. Before this, and before the joining of the monarchies, which takes place after the death of Queen Elizabeth I in 1603, we have James IV of Scotland become James I of England, and he becomes joint ruler of both Scotland and England, with, depending on whereabouts you're from, him being referred to as James IV if you're from Scotland, or James I if you are from England. Scotland and England, before all of this takes place, however, were distinctly separate entities, and in fact they were often embroiled in numerous conflicts with each other. If you look and study any of the nearly 1,000 or so years before the development and the Acts of Union between the two countries, you will note that there are lots of skirmishes, lots of battles, lots of conflicts that take place. And given that for a significant period of history, should I say, England and Scotland have been separate, their legal systems have stayed separate. But this does not answer the question as to why the legal systems are separate to this day. Because you could suggest that, well, with the Acts of Union, surely that means that the legal systems are going to be made merged together, and they're going to then develop in conjunction with each other. Well, when it comes to the Act of Union, one of the things that was very much cited and codified within the Act of Union is this idea of the preservation of Scots law. The Act of Union of 1707, within Title 19 of this Act of Union specifically, it noted that while Scotland was to join with England in a United Kingdom, in the establishment of Great Britain, Scots law, the Scottish legal system, would be preserved within Scotland. Now, what this essentially means for students of English law and students of law from any jurisdiction in this particular region is that it does make for some kinds of complexities. Because while it is true that Parliament, in creating legislation, creates legislation which binds Scotland, in terms of the development of case law and the common law in England, that is separate to that of Scots law in Scotland. So we will talk about the powers of Parliament and the ways in which legislation is created in future lessons' time, but it should just be noted that when we talk about, for example, the criminal law, we are either going to be referring to Scots law or the law of England and Wales. On this channel, we're going to be referring to the law of England and Wales. If in the future we might do a series of lessons on Scots criminal law, but for now we're going to focus on England and Wales. And this brings us to the scope of this series. Essentially, what this course will do is provide you with a detailed examination of the English legal system. This is going to be knowledge and skill that is going to be vital for your understanding of how law operates within this jurisdiction. So it's not going to be law that is specific to a particular topic. So we're not necessarily going to be focusing all our time on family law or medical law or criminal law. We're going to be focusing on just the way in which law is administered and made generally holistically, and we might use case studies from all the different various areas of law as and when we go. So essentially, the first major topic in this series is going to look at the sources of law within England and Wales. This involves an introduction and an examination of how law is made, and where it is made from. So, including the ways in which lawmaking is made, lawmaking is done, should I say, through the parliamentary model, through Parliament, i.e., how laws are passed in Parliament, the interpretation of statutory legislation. Statutory legislation and statutes refers to parliamentary legislation, as well as the structure of courts in the creation of the common law and the principle of precedent. We're going to talk about the various different ways in which we interpret case law decisions, including things like principles such as the idea of stare decisis, ratio decidendi, etc., etc., etc. We will also talk about other sources of law which are external to not only England and Wales but also the United Kingdom. So we'll talk about the ways in which international law operates and binds onto the English legal system through the signing of treaties, for example, and the interpretation of international custom, as well as the impact and influence of the European Union, an institution for which we were a member for a great many years. We will then, in our second topic, talk about the idea of courts and tribunals. We'll talk about the structure of the judiciary, we'll talk about the types of courts that exist, the distinction between the civil jurisdiction and the criminal jurisdiction within the court structure, administration of law in both courts and tribunals, as well as the various principles that underpin the appointment of the judiciary and members of the judiciary. So things like, for example, independence of the judiciary and security of tenure, for example. In the final major topic, we're going to talk about the role of professionals within the legal system that we live in, as well as the access to justice issues that exist. So this means a distinction between the barrister and the solicitor within a legal case, the concept of legal ethics, we'll do a very basic overview of that, the concept of legal aid and funding, and access to justice in both the civil and criminal jurisdictions. Now, when it comes to looking at various textbooks in relation to the English legal system, many textbooks then would go on to talk about the criminal justice system and the civil justice system in a lot more detail. The reason why we're not going to do that is because we're going to save those two topics for their own separate series of lessons. So we're going to do a whole series of lessons that will be as large as this series of lessons on the criminal justice system and then on the civil justice system as well. That will all form part of both an introductory topic, which is this topic, and then some more advanced topics on the ways in which the structure of the English legal system operates.